Good evening, ladies and gentlemen, and a very warm welcome to everyone who is joining us from around the world. Thank you for joining us for the SIAC-CIArb Virtual Debate 2021. My name is Emmeline, SIAC's Business Development Manager, Legal, and I am pleased to be your MC today. The outcome of today's debate will be determined by our panel of judges. However, as participants, you will have an opportunity to vote on the outcome of the debate as well as the best debater. There will also be a Q&A with the debaters after the debate. You may send your questions to the debaters using the Q&A function. We will now have Mr. Paul Sandosham, Chairman of SIARB and partner at Clifford Chance Asia, to deliver the opening remarks. Mr. Sandosham, please.
Emmeline, and good morning, good afternoon, and good evening to everyone who's joined us this evening or today. The evening was to start with an opening address by Ms. Lim Seok Hui, the CEO of SIAC. As is apparent, I'm not her. She sends her apologies as she's held up by a prior engagement. As Emmeline mentioned, I'm the chair of the Singapore branch of the Chartered Institute of Arbitrators and the moderator for this evening's debate. It is my pleasure to welcome all of you to the annual CIArb SIAC debate. I am delighted that we can host it this year after a lapse of 1 year in 2020 due to the COVID-19 pandemic. Those of you who have been attending the event the past years will know that this is one of our flagship events. We usually have to turn away registrants because of limited physical capacity at the venues where we hold the debate. But because we are holding it virtually this year, we have no limits in terms of numbers of people who can attend. And I'm pleased that we have a total of 466 people who have registered and have logged on and who are joining us today. So fantastic turnout. So in terms of the debate motion, as you would have seen, the topic for discussion is this House believes that arbitral institutions must impose a limit on the number of repeat appointments from the same party. Thank you to the SIAC and CIArb Singapore for coming up with this thought-provoking topic, and thanks also to Michael Huang, who provided some input on this topic. So without further ado, I'd like to start the evening by taking a poll. So in addition to the judges' views on the outcome of the debate, you get a say. So on that note, there will be a vote now on the debate motion, which will be put up on screen in a short while. So please do vote one of the options, either agree or disagree. You have 1 minute and your time starts now. Okay, close. The voting is closed. Wow, okay. The audience have spoken. It's now for the debaters to persuade us either way. So without taking up any further time, could I first start by inviting the first speaker for the proposition, Mr. Nigel Blackerby QC, to present his arguments. Nigel?
Thank you to the SIAC. Thank you, Paul, for the honor of having been invited to debate this important issue. I just make the usual disclaimer that the views here are expressed for the purposes of the debate and do not necessarily reflect my views or those of my firm. Now, I will be appearing today with my colleague Mahesh Ray in favor of the motion that arbitral institutions place a limit on the number of repeat arbitrator appointments by the same party. I'll provide an overview of the key issues we intend to address before turning to them in detail, and at the relevant juncture, I will indicate which points Mahesh will address in his later presentation. Now, before starting, I want to be clear about what the motion concerns and what the motion does not concern. It concerns repeat appointments by a party. We are not talking about repeat counsel appointments. The motion is also not against party appointment per se, rather repeat party appointment. Finally, the motion does not seek to be prescriptive to arbitral institutions. It is in favor of limitation, but each institution is free to prohibit or limit repeat party appointments in the manner that best suits its own needs and the needs of its users. So with that in mind, the core arguments in favor of this motion can be broken down into 7 propositions. First, Repeat party appointment is an old issue, the risks of which have already been debated and a clear conclusion reached by the arbitral community in the IBA guidelines on the conflicts of interest. On the underlying principles, there is nothing left to debate. Second, given the ever-broadening choice of competent international arbitrators, a repeat appointment of an arbitrator by the same party incorporates a risk of an implicit bias or a quid pro quo to favor the appointing party. Third, even if an arbitrator claims to be impervious to such risk, data and studies show that conscious or unconscious bias impact conduct of a repeat party appointee, thus affecting the impartiality of that appointee and thus the credibility of the arbitral process as a whole. Fourth, even if that were not the case, for the credibility of the system to be upheld by its users and the judicial systems that underpin it, the actual state of mind of the repeat appointee is irrelevant, as the appearance of bias created by repeat appointment is as important as bias itself. Justice must be seen to be done. Fifth, allowing repeat party appointments undermines the arbitral community's attempt to support diversity by allowing a younger, more ethnically and gender diverse core of arbitrators to evolve. Sixth, repeat party appointments in related cases create an unfair advantage to the appointing party, leading to an imbalanced tribunal and a possible prejudgment of the issues. And seventh, there is already a live debate concerning the credibility of party appointees per se. Allowing repeat appointments undermines the party appointment system and provides a strong argument to those who want to abandon party appointment altogether in a semi-judicialization of international arbitration. So with that run through the points, let's turn to them one by one. First of all, this is a stale debate that has already been resolved in the IBA guidelines. My colleague Mahesh Ray will address this question, but in sum, what is proposed here should be very uncontroversial. The IBA guidelines already limit the number of repeat party appointments and were the result of a consensus established following a detailed debate in the arbitral community. That debate should not be reopened. The only remaining issue is the need to make such a rule binding by incorporation into institutional rules. The second point, for most commercial parties, international arbitration is an infrequent occurrence. Unlike specialist counsel in a large arbitration group, who may be engaged in the appointment of upwards of 100 arbitrators a year, the average corporation has one international arbitration every few years. Even the most litigious are unlikely to nominate more than 2 or 3 international arbitrators annually. And in parallel, whilst there's still much work to be done, the corpus of experienced international arbitrators is ever larger, with successful initiatives to expand that base bearing fruits, such as the Equal Representation in Arbitration Pledge. For example, the IAI Paris website lists more than 600 highly qualified international arbitrators. Now, given that a party will have a broad choice of competent, independent, and impartial arbitrators from which to choose in the infrequent referrals it makes to arbitration, the question to be posed is, why would a party choose the same arbitrator? The answer must be that any attempt to repeat an appointment must be linked to a perceived quid pro quo. Think about it. In Washington, D.C., where I live, there are about maybe 200 good restaurants. I could go to a different restaurant every week for 4 years. But if that happens and I go to one of those restaurants once, I'll likely be treated as every other customer. If I go to the same restaurant twice, they may remember me and treat me slightly better. If I go every week, I will likely be greeted by the Metro D and offered the best corner table. Why does the restaurant do that? Because I am a repeat customer, and repeat customers get the best treatment as they are a guarantee of future income flow. It's human nature. Now, this is not just my view. In Halliburton and Chubb, the UK Supreme Court noted that unlike a judge, an arbitrator is nominated, and I'm quoting, to act by one or both of the parties to the arbitration. He or she is remunerated by the parties, and if arbitral work is a significant part of the arbitrator's professional practice, he or she has a financial interest in obtaining further appointments as arbitrator. Close quotes. Now, of course, the arbitrator community and the opponents of this motion will no doubt argue that they are superhuman creatures, suspended above worldly concerns, who will be impervious to the financial benefits of repeat appointments. Ethically, they say, they don't operate like any other business. But even if that were true, studies have shown that arbitrators are human beings who are subject to the same unconscious biases as other mere mortals. This brings us to the third point. Conscious and unconscious biases are exacerbated in a repeat appointment situation. Now, my colleague Mahesh will address this question in more detail, but as he will show, studies have revealed how party appointees have a tendency to favor the party who appointed them. But ask yourself the question, why is that the case? No doubt the hope of a repeat appointment by that same party. If such a possibility were removed or limited, the arbitrator would be freed from that risk. Future revenue as a consequence of a repeat appointment from that party would be impossible. The prohibition of a repeat appointment or its limitation thereby underpins a credible party appointment system. Fourthly, even if there were no bias, justice must be seen to be done. The international arbitral process does not exist in a vacuum. It provides a service to international commerce and investment. And in order to thrive, it must generate confidence in the users and in the states who support the enforcement of its results. So irrespective of whether there really is a quid pro quo or really is a conscious or unconscious bias in a repeat arbitrator, what matters is that the system as a whole must believe that the only issue in question is an impartial and independent decision on the merits of the case. The mere appearance of bias is therefore as dangerous to the system as bias itself. Mr. Ray will address this issue in more detail in his remarks. On the fifth point, repeat party appointment undermines diversity. Quite apart from the risk of bias, repeat party appointment prevents a party looking objectively and neutrally at the full pool of suitably qualified candidates for a dispute. Sticking to the tried and tested will result in the repeat appointment of a small band of elderly, usually male, arbitrators, and stifle the development of a younger, more ethnically and gender diverse arbitrator community. If the core of arbitrators is not successfully renewed between generations, then we know that international arbitration has no future. Limitation or prohibition of repeat appointment forces parties to look outside their comfort zone into new appointees from different backgrounds and age groups. Arbitral institutions have played a key role in fomenting diversity, and so should support this motion, which will constantly force parties to look at new candidates. The sixth point, repeat party appointment in related cases results in prejudgment of the issues and imbalanced tribunals. Now, parties may tactically repeat appoint an arbitrator in related cases, hoping to obtain a benefit from an arbitrator who has seen another aspect of that same dispute. In other words, an arbitrator who in a second or third arbitration has an added insight or knowledge not possessed by the other arbitrators. For example, in a dispute involving an insurance contract between an insured and an insurance company, the insurance company may appoint arbitrator A. He may then seek to repeat appoint the same arbitrator in a dispute under its contract with the reinsurer. Now, this gives arbitrator A a clear benefit over the other arbitrators in the second arbitration. A prohibition of repeat appointment in related cases, absent agreement of all parties, would cure such undesirable situations. And similar problems may arise in investment arbitrations, where a state may be sued in different arbitrations in respect of the same investment by different shareholders. If the state repeat appoints the same arbitrator, there will likely be a prejudgment of the issues in the first arbitration that will transfer to the later arbitrations. This motion would prevent such risk. And finally, the seventh point, repeat party appointment undermines the credibility of party appointment per se. Proper safeguards on repeat appointments will assist in protecting the fundamental right of a party to identify and nominate a suitably qualified, independent, and impartial adjudicator. The movement in favor of abolition of party appointment is gathering steam. Yet one of the very hallmarks of international arbitration is the possibility of the parties participating in the formation of the panel that will judge their dispute. It's one of the elements that creates credibility in the system for the users. But since repeat appointments create the damaging incentives towards bias, conscious or unconscious, they play into the narrative of the abolitionists. When repeat appointments are prohibited or limited, those incentives and risk of bias disappear or are strongly mitigated. This motion therefore underpins a fundamental element of the international arbitral process by supporting the concept of party appointment per se. Now, those conclude my opening remarks and will be completed by the remarks of Mr. Ray later. I thank you very much for your attention and obviously we'll be happy to answer any questions. Thank you.
Thank you, Mr. Blackerby. If I could hand over the time now to Dr. Tai Hing Ching, who will speak for the opposition. Tai Hing.
Thank you, Paul. It's such a pleasure to be here. Good evening to everyone. I'm joining you from New York, unfortunately, as I haven't yet been able to get into Singapore, but the moment the borders open, I will be right home and with you all. But it's nice to see you all virtually today. Let me start with re-looking at the motion to make sure that we're actually not misunderstanding it and not two ships passing in the night. The motion provides that arbitral institutions must limit the number of repeat appointments. And I'd like to focus on three words, or rather two terms. First, arbitral institutions, and second, must. Mr. Blackaby has posited a normative position, which is that arbitral institutions should limit the number of repeat appointments, in support of which he has put forward a number of normative arguments, preventing bias, avoiding implicit bias, supporting diversity, and so on. But that is not the motion that is before the House for debate. The motion is whether or not arbitral institutions must do so. In other words, is there a legal obligation upon arbitral institutions to limit the number of appointments? I put it to you that there is no such legal obligation. By his own admission, Mr. Blackaby points to the IBA guidelines on arbitrator conflicts. In terms, those are only guidelines and not legally binding. They may be soft norms, they may represent the existing normative consensus. In fact, they do provide guidance, but they are not legally binding on arbitral institutions or arbitrators who are free to depart from those guidelines as circumstances require in the judgment of the arbitral institutions. Is there any other sense in which arbitral institutions must limit the number of repeat appointments? I put it to you that there really isn't. There is no normatively, or rather legally superior governing body that instructs arbitral institutions as to what their rules should be and how to apply them. Now, one may say, when it comes time to challenge or recognize an award, the supervising court will make its own mind up as to whether or not an arbitrator was so biased as to infect the award and could take into account repeat appointments. That is certainly true. However, that is simply a question of whether the award stands or falls, not a question of what the institution must or must not have done. And moreover, the applicable arbitral law, the lex fori in different jurisdictions is different. And so it's impossible to say that, for example, the Singapore courts will reach the same position as the UK courts or the US courts. And so even there is no global standard that is a legal obligation imposed upon arbitral institutions. Now, I realize this might strike some of you as a little too cute. This is a debate, but I'm not being cute. I'm taking the motion for what it is. And I hope I can persuade you all that the fight today is not the normative fight as to whether or not arbitral institutions should limit the number of appointments. The debate before the floor is whether there is a legal obligation on arbitral institutions to do so. Must it do so? And in that regard, it is clear as day, as a matter of black letter law and common sense, that there is no such legal obligation on arbitral institutions. Well, lest we truly end up as two ships passing in the night, let me now turn then to engage with the proponents on the normative question of whether arbitral institutions should impose a limit. In other words, contrary to the motion that is to be debated, let me pretend the motion is something entirely different, let me pretend it's the motion that the proposition would like to debate, not the motion that is before the floor, and address whether or not arbitral institutions should limit the number of appointments. And here, I would just like to foreshadow that my colleague, Ms. Elaine Wong, will grapple with those questions in greater detail. She will address the questions of bias or perceived bias and the logical fallacy contained therein, and some of the other points of a normative nature that Mr. Blackerby raised. I would like to only say this: even as a normative matter, it should not be the arbitral institutions that decide on the number of repeat appointments. And the reason is, we now have a diversity of arbitral institutions all around the world, and it will be a nightmare if the SIAC says the rule is 3, the ICC says the rule is 4, the NYAC says the rule is 5, and the LIAC says the rule is 6. Rather, we need global uniformity. Arbitration is a global system of dispute resolution that is intended to bring about certainty and predictability at a global level to promote global commerce. To that extent, the normative question, in fact, ought to be answered as, if there is going to be a limit, it should be a global standard and not up to the arbitral institutions to each separately decide. Mr. Blackerby appears to have conceded that point, indeed, in his opening remarks, where he pointed to the IBA guidelines, where he said the debate's been settled. The rule that ought to be in place is in the IBA guidelines. Well, that's not a rule of arbitral institutions. That's a global soft norm generated by a global body. And so, in other words, even if we concede that the number of arbitral repeat appointments should be limited, the question is who decides? And the motion before the floor posits that arbitral institutions should decide. And I put it to you, it should not be arbitral institutions, but rather a global soft norm generating body like the IBA, which makes that decision as to what the normative framework ought to be. And in fact, that is what happens in the world as it exists today. And in fact, it is what Mr. Blackerby has already implicitly conceded is what should take place. Finally, I won't go too much into the question of perceived bias or actual bias, as Ms. Wong will cover this, but I'll end on this anecdote. The devil really is in the detail. Whether a repeat appointee is biased or perceived to be biased depends on the facts of the case. Judge Brower, Judge Charlie Brower, was a repeat appointee of my law firm, in my previous law firm, in a number of cases. But I appointed him because in the prior arbitration, he found against my firm's client. In that situation, it is not one where someone has received repeat appointments and is constantly finding in favor of the law firm's clients, precisely because Judge Brower established his independence from the prior appointment. Did I appoint him again in the next arbitration? I ask you, is that the sort of repeat appointment that a numerical rule should prevent? Again, a blunt instrument simply doesn't capture the nuances of repeat appointments. On that, I rest and I turn over the floor. Thank you all for your attention.
Thank you, Tai Heng, and to you, Mahesh.
Good evening, everyone. It's a pleasure and honor to appear today. Before I launch into the 3 points I wanted to make, just 3 points of reply to Tai Heng. By making the motion about a legal obligation, Tai Heng avoids the issue, the real issue, which is whether institutions should impose such a limitation. If you read the summary that is provided by the SIAC, it says, as the appointing authority in the arbitration, institutions are in the position to impose safeguards to protect the integrity and sanctity of the arbitral process and international arbitration as a whole. So this is a classic debate technique. By taking the motion to its extreme, Dr. Tai Heng gets to avoid the issue, which is obvious on the fact that he has not addressed any of Nigel's 7 points other than the IBA guidelines, which I'll get to. The second point is his Judge Brower example. He said, and I quote from his previous firm, Once again, if we read the motion says repeat appointments from the same party. We are not talking about repeat appointments from counsel or their firm. That is a motion to be debated another day. We are talking about repeat appointments from the same party. And the third point, which is that we are barking up the normative tree. We are really not, because the normative debate has been settled. And that leads me to my first point, which is that the ship on the motion, while Tai Heng and Elaine were not watching, has already sailed. What the motion aims to do is to rein in repeat appointments so that a repeat player does not develop financial dependence or partiality on the party nominating him or her. What the opposition seeks to ignore is that the community has already spoken in support of what the motion seeks to further. Both financial dependence and repeat appointments are already accepted as circumstances that can lead to justifiable doubts to impartiality and independence. First, on financial dependence. If an arbitrator or his firm regularly advise a party or even an affiliate and they derive significant financial income for this, this falls within the non-waivable red list in the IBA guidelines. The community felt that this situation cannot possibly be waived because it would lead to justifiable doubts. It stems from the principle, no one is allowed to be his or her own judge. And if there's a significant economic interest in the matter, there is identity between an arbitrator and a party. That is the very same scenario that the motion against repeat appointments seeks to protect against. With repeat appointments, the financial interest of the arbitrator gradually becomes aligned with that of the party. If your bread is always buttered on the same side, you naturally bend in favor of that side. Second, the very problem of repeat appointments is found in the orange list. Two or more appointments of an arbitrator by the same party would be an orange list circumstance. This was the case, it was already settled in the 2004 guidelines, and again, it remained the position in 2014 IBA guidelines. And it's not just the IBA guidelines which reflect the consensus in support of the motion. In the 2015 Queen Mary survey, when asked the question whether repeat nominations of the same arbitrator in multiple arbitrations by parties should be, I quote, specifically regulated, 72% of the respondents said yes for commercial arbitration, and 76% of the respondents said yes for investment arbitration. The consensus is already there in the community. It is now time for the institutions to answer the clarion call and regulate repeat appointments through the institutional rules. Now, the opposition has tried to argue, and that's the point, that's the only point that Dr. Tai Heng actually turned to, which is that the IBA guidelines are good enough, but the simple reason that they're not good enough is this, and Nigel has demonstrated this. Repeat appointments go to the essence of due process and affect legitimacy. It's not good enough when we are dealing with due process and legitimacy for compliance to be optional or voluntary, which they are at the moment with the IBA guidelines. Institutions should regulate such appointments in their rules, and that would be protecting due process and diversity. On to my second point, which is that the propensity for bias is exacerbated in a repeat appointment scenario. To begin with, even leaving aside repeat appointments, there is already a tendency for bias towards the party nominating the arbitrator. This is borne out by two studies showing that arbitrators not only feel an affinity, but they feel obliged to indulge in quid pro quo behavior. In the now famous Jan Vandenberg study of 54 investment arbitration awards, 37 awards had a dissent. Every single time there was a dissent, it was by the party appointed arbitrator in favor of the party nominating him or her. Commercial arbitration in the second study fares no better. A study by Alan Redfern found that more than 95% of the time, dissenting opinions came from the party arbitrator in favor of the side that nominated her or him. This fact alone, that 95 to 100% of dissents came from the party nominated arbitrator, siding with the side nominating him or her, shows the real propensity for bias in the system of party appointed arbitrators. We don't even have to go to the more egregious cases of arbitrators from leaking confidential information to his nominating party, like in the Croatia-Slovenian case, to show that he who pays the piper calls the tune. The problem we submit can only be made worse with repeat appointments. If the arbitrator's appointment comes time and again from the same party, there is a very real, and we submit, human tendency to lean in favor of that party. Now, a further point on unconscious bias underscores why the motion should be supported. And a simple cognitive question illustrates this. You have 1 kilogram of feathers and 1 kilogram of lead weights. Which one weighs more? The intuitive answer would be 1 kilogram of lead weights. But the actual answer is that they both weigh the same, 1 kilogram. Unconscious bias stems from the fact that the intuitive part of your brain, often called system 1, works faster than the deliberative part of your brain that requires more time to process the information. In a study entitled Inside the Arbitrator's Mind, 80% of arbitrators failed similar types of cognitive reasoning tests. What does that tell us? Arbitrators are human beings after all. They are not immune from unconscious bias. And we submit that in many cases that all of us have done, the evidence of the law is ambiguous. The position of both sides is evenly balanced. And that's where we say that there's ample room for factors like unconscious bias to influence the outcomes in arbitration. And that, in turn, is what infects the legitimacy of arbitration and cuts against due process. Even if we think that there's no actual bias, arbitrators who are repeatedly appointed could unconsciously be biased without anybody knowing. On to my third point, which is that perception is reality. And that is the point of appearance of bias. We've all heard the maxim before again and again since law school. Justice must not only be done, it must be seen to be done. Even if we accept the position that there is no bias, justice must still seem to be done. The appearance of bias is a real threat to the arbitration regime. When you consider that proving actual bias is extremely difficult, if not impossible. What about unconscious bias? That, we submit, is even worse. Searching for unconscious bias would be akin to, and I quote, making windows into men's souls in search of an animus for a party, unquote, in the words of the UK Supreme Court in the Halliburton case. Now, the mere fact of repeat appointments gives rise to the appearance of bias. There is the risk, however unjustified, that a party may feel that an arbitrator will acquire inside information from the previous arbitration, or might learn something favorable about his nominating party, who appoints him again and again. Even if there was no bias, this is what we call arbitral FOMO moment, fear of missing out. The other party would feel that the previous arbitration was a dress rehearsal to which the party appointed arbitrator and the side nominating him got to attend, and then a rehearsal to which they were not invited at all. Now, as Nigel foreshadowed, arbitration is a service to the international community, and the popularity and rise of arbitration as a mechanism of choice to resolve disputes is particularly because of the faith that the users place in the system. If repeat appointments by a party were allowed to go unchecked, this would soon erode the faith that the users of the system place in it. So arbitration not only needs to be fair, in fact, but its users also need to regard it as fair. We already accept at the moment that repeat appointments by a party can give rise to an appearance of bias. In fact, from Dr. Tai Heng's submissions, you can see that that proposition is already accepted. We submit that it is the right time to take that additional step further and to take active measures against this. And the best way to do this would be through the institutions. And we are not suggesting to bring a sledgehammer to hammer in a nail. What we are saying is the institutions should be the ones who actually impose the limitation. It is up to the institution how many appointments that can be. In LMAA or GAFTA arbitrations, the number may be different because the market that they operate in is completely different. That's in the exception number 5 to the IBA guidelines. In ICC, SIAC-CIArb arbitration, the number may be different. So each institution gets to take a look at its caseload and its track record and its history and decide for itself, when it comes to its own institutional rules, how many appointments is too many. And for those reasons, ladies and gentlemen, we would urge you to support the motion. Thank you.
Thank you, Mahesh. Before I hand over the time to Elaine, can I just remind the debating teams that you have a 5-minute rebuttal. So after Elaine is done, one of you from the proposition will be entitled to rebut. And after that, one speaker from the opposition, whether it's Ms. Wong or Dr. Cheng, you will have the opportunity to rebut. So could I hand over the time now to Ms. Elaine Wong?
Thanks very much, Paul. I think anyone who knows me knows that I like to have the last word. So I'm very privileged to be the fourth speaker for today. The motion that we have today, I think as Taiheng has mentioned, it says this House believes that arbitral institutions must impose a limit on the number of repeat appointments from the same party. And we've heard from Nigel and from Mahesh that this is a must, that the integrity of the arbitral process requires this. But the assumption that repeat appointments lead to bias is far too glib. I agree that arbitrators are human, and for the most part, humans are driven by self-interest. However, it's far too simplistic to say that an arbitrator will render an award favorable to the appointing party in order to garner more appointments from that party in the future. We all know that arbitrators care deeply about their reputation, their standing in the arbitration world, and yes, lawyers are sad that way. We want the esteem of our colleagues. So Nigel mentioned the fact that he likes to be a repeat customer at a restaurant. He gets special treatment from the maitre d'. Who wouldn't want that? My question to Nigel is, would you rather be a repeat customer at an old, tired restaurant that you've been to 20 times? Or would you rather go to the hot new restaurant where everyone's dying to get a place at? I know what I'd rather do. In fact, we all know that an ideal arbitrator is one who's impervious to challenges. And actually, repeat appointments could well be the result of the arbitrator's reputation for independence and impartiality. Let me give you a real life example. Many, many years ago, obviously pre-COVID, I was at an international arbitration conference. It was held in Hong Kong. All the great and good, congregated there for 3 days of debates and I guess 3 nights of drinking cocktails and networking. And it was supposed to be a masterclass on becoming an arbitrator. And so after a day or two, one attendee stood up, put up his hand and said, "I've got a question." He looked at all of us and he said, "Okay, guys, come on, let's cut the crap. We all know that, when you're appointed by a party, you're beholden to that party, right? So you kind of owe them something and you want to do right by them. That's only fair, isn't it?" So there was a really awkward silence in the crowd and everyone looked around and said, "All right, what do we say to this individual?" And I think one of the moderators of the panel, had quite a good response. And she said, "Well, sir, do you want to be a small-time arbitrator who's appointed in essentially domestic arbitrations, or do you want to build a practice as a truly world-class international arbitrator?" I'm assuming her question was a rhetorical one. Look, even if someone has been appointed repeatedly, and that person isn't actually disqualified through a challenge process, no one likes a hired gun. And we all know that within a 3-member tribunal, an arbitrator who has a reputation for being biased will have less clout and influence on the other members of the tribunal. So in that case, if you're the party who has appointed the arbitrator, that person now has little influence, and the outcome of the arbitration will be decided by the other 2 arbitrators. So the chain of causation is broken. There's no point appointing the biased arbitrator. And think about it in another way. Why does the arbitrator want to favor the appointing party in the award? People are such that they take for granted what they already have, and they fixate on getting what they don't have. So a shrewd arbitrator will want to get more appointments from both parties. Why focus only on the party that has appointed you? And in fact, some studies show that arbitrators who want to get future appointments from both parties will actually issue compromise awards. So awards that are neither here nor there. I think the proposition spoke a lot about how there might be an unconscious bias that arises from being appointed by the same party repeatedly. But look, we all know that familiarity breeds contempt. Some will say that familiarity with a party leads to feelings of indebtedness. You have a sense of goodwill or a sense of obligation. But studies have shown that there is an inverse relationship between knowledge or familiarity and liking something. Think of your mother-in-law. Think of how much more you would like her. You saw just so much less of her. I know I've benefited from having my mother-in-law live in an entirely different continent from me. So if that doesn't settle the debate, let me point out another obvious point. The numerical rule is unworkable. An absolute numerical rule is a blunt instrument. It's not fit for purpose. I mean, what is the magic number? Why does the IBA rules set out 2 appointments in the past 3 years? Why not 1 appointment in the past 6 months or 3 appointments in the past 2 years? I mean, does it matter if the arbitrator was appointed by the same party in a case which settled before any award was rendered? Any absolute numerical rule is arbitrary, it's inflexible, and is not adaptable to the situation at hand. If we want to use numbers, at most, I would say we should look at the percentages rather than an absolute number. We could, for example, look at the percentage of appointments that an arbitrator has received from the party out of the total number of appointments he or she has in a year. Or we could consider the proportion of expected revenue to be generated from the appointment as compared with the arbitrator's total income. But good luck trying to get lawyers to declare what their total income is every year. I think the proposition has spoken about diversity and how important it is to ensure that we allow others from different ethnicities, gender, to have a chance to act as arbitrators. As an Asian female, I'm very grateful to Nigel for having raised the point, and I agree that we could do with fewer pale, male, and stale candidates. But look, there are other ways to deal with these things. And there's already so much going on in the arbitration world to encourage diversity among appointments. We have the Equal Representation Pledge, which I think is a brilliant initiative. We have different ways of dealing with these issues. So at my firm, we put together a list of arbitrators who are just not as well known. It could be that they come from a different country, or they could be women, but of course it's not limited to that. And we try to raise awareness amongst the entire team so that people know that there are different people with different attributes that could be used for different types of cases. I have to say that by and large, quotas don't work. We don't achieve what we want to do when we impose a blunt instrument such as a quota. We talked about prejudgment of issues, but surely we also value certainty and consistency. In cases where issues are related, or there are common issues to be decided, we want to avoid the possibility of inconsistent decisions. And finally, I want to touch on the fact of party autonomy. I think it is a very critical element in international arbitration, or it is the ability of the parties to select their arbitrator. I know that there are people who are criticizing this or trying to overturn this now, but many of the users of arbitration value this, and they want to be able to select who was then judgment of their dispute. There is no legal basis to disqualify arbitrators because of repeat appointments. The laws provide for a duty of independence and impartiality. The laws do not talk about repeat appointments. And let's be honest, the IBA guidelines do what they say on the tin. They are guidelines, not laws, for very obvious reasons. I think a lot of people are confused about what the orange list represents. It's a list that pertains to the need for disclosure. They are not grounds for disqualification. We can't be lazy and just impose a numerical limit. We need to look at the situation case by case. We don't want to give parties a means by which they can mount tactical challenges in order to disrupt the arbitration process. We all know that a lot of challenges that parties raise can be easily dealt with, but some are just used in order to disrupt the proceedings and to cause immense delay. Look, there's lots to say about this, but I think I'll end with a couple of cliches, and sometimes cliches have the seed of truth in them. Let's go with quality, not quantity, and let's put substance over form. Thank you, everyone.
Thank you, Elaine. Your mother-in-law has put in a comment in the chat, which it's not appropriate to read out. Could I hand over the time now to one of Nigel or Mahesh to do the 5-minute rebuttal, and then thereafter either Elaine or Tai Hing will get a chance to respond.
Thank you, Paul. I will take the rebuttal. Now, most of whatever Elaine has said, as you can see, it's not based on the actual trends in the arbitration community. And you can see that from the 4 or 5 examples that she raises, all of them are anecdotal. Now, to the first point about arbitrators caring about their reputations and about hot new restaurants and her cocktail anecdote about, about the goodness of arbitrators, the point to be made is as simple as this. If we are really to rely on the goodness and the good faith of all arbitrators everywhere, there will be no need for rules on conflict of interest. There will be no IBA guidelines on conflict of interest. There wouldn't have been a huge clamor in the 90s and the early 2000s in the investment arbitration communities about repeat players, which then led the IBA working group to settle on the number of appointments and non-waivable red lists. Elaine's point on the goodness of arbitrators also does not do anything to address the question of unconscious bias or the appearance of bias. So onto the point about them being judged on their quality and relying on the quality of the judgments to get repeat appointments. The point is very simple. We have really proven that it's difficult to detect actual bias, unconscious bias, or conscious bias. The limitation that we are proposing that the institutions takes addresses this problem because it addresses biases that are impossible to prove objectively, but are almost certainly there. So how do you actually rope in a negative? How do you show that an arbitrator was not influenced by repeat appointments? It is extremely difficult. And it is for that reason that we say that institutions should step in and they should regulate the number of appointments. Now, that's where we actually deal with the second point, which is what Elaine dealt with, which is why would you want to side with the party that actually appointed you? How then does Elaine and Tai Hing actually deal with the statistics on dissenting opinions? It's not pure happenstance that 100% of all dissents came from the party nominated arbitrator in favor of the party nominating him or her. Such a statistic is embarrassing for the community at large. And they cannot deny that delegitimizes the entire arbitral regime. And that is the precise type of circumstance that we are trying to guard against. On to the third point, that percentage of appointments somehow relative to the income and not numbers actually matter in terms of the appointments. And Elaine captured it all in her throwaway line, good luck trying to get lawyers to disclose their income. Now, in the OPIC and Karimum Investment Arbitral Award, the co-arbitrators were lucky in the sense that Philip Sands QC's income, they could derive it from the fact that he taught at UCL and whatnot. In other cases, it's extremely difficult to actually tie in the repeat appointments with another factor, like financial dependence. And so when Elaine is saying, good luck trying to get lawyers to disclose their income, she's in effect conceding the motion. She's making the ground, she's essentially establishing the basis for why there should be a limitation to the number of appointments insofar as institutional rules is concerned. Then onto a fourth point about different ways of promoting diversity. Again, that's the anecdotal evidence of her good firm, and they may have various ways of promoting diversity, but that doesn't really answer Nigel's point, which is that how does the pledge work if you keep appointing the same female arbitrator again and again? It doesn't. You are in effect breaking the pledge because you are not considering other female candidates. And about the goodness of the hearts of other people, we have seen that people are not very good because at the end of the day, in the process, all lawyers and parties want to do just one thing. They want to win at all costs. And Martin Harter said it right. When he's looking for an arbitrator, he's looking for someone with maximum predisposition towards his client with the minimum appearance of bias. That encapsulates how difficult it is to actually detect bias. And why are the institutions the right body to actually deal with this? We have seen that we've been making lots of noises about age and gender diversity, about appointing younger arbitrators, female arbitrators. It took the ICC, the LCIA, the HKIAC, and the SIAC to make strident steps in that direction before younger arbitrators were appointed, before females were appointed. And in the ICA 2020 study, it proves it. The institutions were the ones who were actually behind promoting this level of diversity. And now we are just saying that the consensus is already there in the international community. It has been there since 2004. All we are asking the institutions to do is to take one step further and impose a limitation. What that limitation is, it's up to them to decide. Thank you very much.
Thank you, Mahesh. And to end off tonight's arguments, I assume, is it Tai Heng? You on mute. No Zoom call is complete without that statement.
Right, exactly. Paul, thanks so much. It's a pleasure to end this evening's debate. Thank you all for giving me the last word. You know, I confess I'm rather saddened. I thought I was here to engage with the other side, but instead all I've seen is Mahesh ignore the proposition that I'm trying to debate. As I've pointed out, if you take the words of the motion on their face, the question is there a legal obligation on arbitral institutions to impose a numerical limit? Must they do so? And instead of engaging with what the motion actually is, Mahesh turns to the synopsis of this evening to somehow change the meaning of the motion. Now, as we all know from the Vienna Convention on the Law of Treaties, you take provisions according to the plain and ordinary meaning of their words. You only go to the preamble or the treble if there is any ambiguity, of which there is none here. And I put it to you, judges and members of the audience, the reason why Mahesh refuses to engage with the actual proposition is because if he does so, it is self-evident that he loses. There is no legal obligation on arbitral institutions to impose a limit, as in fact, Mr. Mahesh himself has conceded in his statements. In his rebuttal, he said institutions should decide in their own discretion. That's not a legal obligation. That is the opposite of a legal obligation. Now, lest I be accused of not engaging with how they want to treat the motion, let's turn to the two other aspects of the motion that are in play. The first question is, who should decide? And here, as I hear the proposition's arguments, they think institutions should decide for themselves. That on that issue, we simply cannot agree. The IBA as a governing body to provide soft norms and guidelines does provide some degree of uniformity precisely to help arbitration develop as a global system of dispute resolution. It precisely exists to avoid forum shopping. Imagine, for example, if the SIAC took a very liberal view on the number of repeat appointments and the HKIAC said, no, it's a maximum of 2, then parties are going to forum shop to the SIAC, or the inverse. We don't want that. We want parties to pick institutions for reasons other than how many times can I appoint the same person. And in fact, implicit in Mr. Blackaby and Mr. Rai's arguments is that the IBA guidelines are the appropriate governing norm. If you accept that, then the motion has to fail because it is not the arbitral institutions that should decide. It's the supervening global body that should provide the guidelines. So third, let's then take it at a purely normative level. Let's leave aside, is it a legal obligation? Let's leave aside who should decide and turn to the question of, should there be such a norm? And as I heard it, we have on the one hand, the policy of party autonomy, and on the other hand, the policies of avoiding bias and perceived bias and diversity. Mr. Blackaby and Mr. Rai have not disagreed that party autonomy is a crucial key policy in arbitration, because it surely is. If parties don't get to do what they want, they will stop turning to arbitration and go to national courts or go to the Singapore International Commercial Court, which is not a bad thing. But if we are talking about promoting arbitration, then party autonomy must be respected, and that proposition stands unrebutted. So the only questions left then are bias and diversity. In Asia, I'm basically in the majority race, but I spent 25 years of my life being in the minority in America. So I fully understand the importance of diversity, both in youth and gender and ethnicity and all forms of diversity in arbitration. I got my first appointment from the ICC Secretariat at the age of 29, precisely to promote diversity, among other reasons. And so you don't need to put a limit on repeat appointments to promote diversity. And in fact, you may well want to have repeat appointments of younger arbitrators or female arbitrators or ethnic minorities, precisely to build their experience and to build the community of arbitrators globally in a more diverse way. And finally, as to bias, which seems to be the issue on everyone's mind, we all accept that we don't want bias in arbitration. We don't want perceived bias in arbitration. The only question is a numerical limit really the way to attack it? And I put it to you, it is not. Because after all, if a repeat arbitrator by a party, constantly finds against the party, but is still appointed because the party likes the arbitrator, he thinks he's fair, he thinks they gets their views properly ventilated in the tribunal, and therefore is appointed again and again. Should a numerical limit be placed on her? Surely not. And that was Ms. Wong's point. And I think that's in fact Mr. Rai's point when he says institutions should decide in their discretion. So then in summary, even at the normative level, if what we're really concerned is diversity and bias, a numerical limit does not solve that problem. And if we take the motion on its face and ask and say, who should decide? The answer is clearly not the arbitral institutions. And if we really take the motion on its face and focus on the word must, then there is no debate that there is no legal obligation on arbitral institutions to impose a numerical limit on reappointments. I thank you for your time.
Thank you very much, and thank you to both sides for debating the motion so passionately. So now the hard work to the judges. If we could hand over the time to our distinguished panel, and who's going to kick off first? Is it you, Sapna? So this time we'll have the judges will pose questions or comments to the debating teams. We'll get a chance to respond. Sapna?
Thank you, Paul. Thank you all to the speakers for your very passionate and compelling arguments. I have a question for those proposing the motion. One of the key pillars of your position is the evidence that you rely upon. I think you referred to two reports which show that there are unconscious biases on the part of an arbitrator towards the party who appointed them. Yet at the same time, we were told by Nigel in his introduction that you're not arguing for a complete prohibition on party appointments, just for there to be a limit on repeat appointments. And you also told us, I think it was point 7 in Nigel's presentation, that in fact, you're going to save the whole system of party appointments and in fact save the system of international arbitration itself. But I see some inconsistency there between the evidence you rely upon relating to unconscious biases for all party appointed arbitrators, and yet the 2 points I just mentioned, which seem to be part of your position. Could you please help me resolve that inconsistency?
Thank you very much, Sapna. I think I'll take the point. And it is something that certainly when I was first looking at this question, it seemed superficially to be an inconsistency until I started thinking logically through the issue. Because what effectively the position is why is there an unconscious bias in a party appointee? What is it about being a party appointee that creates or could create an unconscious bias in favor of the party who appoints you? And the answer is because there may be a repeat appointment. That's to say that I am thinking about the way in which they will perceive me as a party appointee. And if they perceive me positively, then they may appoint me again. Now, let's take the extreme position of a prohibition on repeat appointments. A prohibition on repeat appointments, in theory, any any part of my brain, consciously or unconsciously, that is thinking, if I please this party, I will gain in the future, will disappear, because there is no basis upon which that party can appoint me again. And therefore, the party has had the freedom to choose the arbitrator of their choice. But at the same time, that arbitrator is not under any motivation, hidden or unhidden, to please that party, because that party cannot then appoint them again. So that's the sense that I say that the repeat appointment is actually what the problem is with party appointment. Party appointment is that the party appointee in the current system, where there may be repeat appointments in many circumstances, is thinking about the next appointment from that party. If that can't exist, then that arbitrator is free, and is free from any unconscious bias, we would say, to decide in favor of that party. Now, of course, when you start building in numbers, the impact of that begins to change slightly. And therefore the question becomes, what is an appropriate number to decide whether or not repeat appointments should be allowed at all, or whether or not they should be limited to 1 or 2 within a particular time period. And that really is just trying to add a dose of realpolitik with regard to certain areas where we have to recognize that certain types of dispute do demand highly technical knowledge, and that therefore to exclude a party that might be going into similar kind of technical industry specific disputes time and time again would not find that after 10 disputes there just wasn't anybody left who would be able to resolve the dispute. So there's a balance to be caught there, but I think we have to look at the extreme circumstance and say, well, if you take away the repeat party appointment, doesn't that improve take away that risk? And if it's not, and then if there's not endless repeat appointments, then again, the influence of that risk of wanting to please will be diluted. And maybe, we have to recognize that we're looking at a mitigation question by limiting the number rather than a complete solution that a prohibition would perhaps create. I don't know if I've answered your question.
You have. That's really helpful. Thank you. I have just one follow-up question, which is, couldn't one take the view that all arbitrators have an interest in future appointments and pleasing parties who appear before them, whether or not, and not just the party who appointed them, but generally they have an interest in being reappointed? And doesn't that undermine the way that you rely on unconscious bias as a key pillar of your argument?
I think the reality is that we all know, and I think that those of us who know the people who work in this community don't think that we're talking about something here that is overt. And I think the point that was made by Tai Heng that of course we have to trust the people that they're making their decision, they're thinking they're making the decision in the needs of justice or in the interests of justice. So much of this is unconscious. So I think the issue that we need to address is look at the data, and the data unfortunately come back to the dissenting opinion point. And the dissenting opinion point is a shocking revelation. We have to assume that all of those, or vast majority of those arbitrators, were deciding in good faith. So either that's extraordinary prescience by the appointing parties as to the way that the issues would be decided in their favor, but the arbitrators would decide in that way, only dissent in their favor, or there is an issue here, and that's data, that's hard data. And so, whilst it is important to be seen to be independent in the eyes of the community, the reality is, unfortunately, that it seems that for whatever reason, when push comes to shove and there's a problem, the problem is always in terms of dissenting in favor of the party who appointed you, and not against that. So yeah, that's the reality. So I think, of course, everyone's trying to impress everybody else, and the overtly biased arbitrator will have 1 or 2 appointments and then disappear into the ether. But we're talking about something far more subtle here, and potentially far more dangerous, and something that, as I think we go back to, we have to come back to this question of appearances as well, because it's not just we're in our little bubble here, and we all trust each other, we know each other, and we've worked with each other in lots of different capacities. But the community we serve, which is the international business community as a whole, isn't part of that bubble. And when you talk about some of the stories to them and the way that the system works, some of them think it's fixed, rightly or wrongly, or that it's going to come up with a certain answer because there's just too few people dealing with these issues. So, we need to, and of course the court system itself, which underpins this. So if the judicial systems are not trusting arbitration anymore either, then that creates a problem. So I think there is an issue. It's probably unconscious in the vast majority of cases, but precisely because it's unconscious, it needs to be resolved by objective rules, which is why guidelines on conflicts, as Mahesh noted, are necessary. It's if we trusted arbitrators implicitly, we don't need any conflicts. The fact that my Singapore office has done $5 million of work for a particular client, I can't act as an arbitrator. Frankly, from my own perspective, would I be biased in that context? I don't think I would. But I understand why I can't act as an arbitrator in that case, because I can understand from outside they might see and have a different perception from my perception.
Thank you.
Dana?
Hello, everyone. Very well argued by all. So, I'm circling around in terms of how I would vote at the end of this. So congratulations to all of you. My question goes to Tai-Heng, and it sort of stems from, you made the point that there's no legal obligation, and I'm not sure that that is the issue before us. I think the issue is informed more by should, and in the language of the motion, must institutions take the lead. And I would ask you to just, for a moment, put yourself in the shoes of your opponent. And in light of the progress made by institutions to progress diversity and actually expand the pool of arbitrators in international arbitration, if we were to borrow from or take note of the contents of soft law that you emphasize are the better source of governing this issue as to repeat appointments, and invite institutions to harmonize and implement what the soft law guidelines suggest, how might you suggest that institutions generically, and to avoid forum shopping, universally implement limits?
Dana, thanks for that question. I fully accept and acknowledge that what we really want to debate is the normative policy that ought to be implemented, because that's the meaty issue. But as you've said yourself, that is the should question, not the must question. And I'm not in a position to change the words of the motion. The motion, unfortunately, posited the obligatory question with the mandatory word must. Leaving that aside and getting to the meat of your question, though, I think that there are multiple concerns as an institution when deciding who to appoint, typically as the presiding, but sometimes as co-arbitrators. And if we're concerned about diversity, a numerical limit on the number of repeat appointments doesn't really address the diversity point, because even if you took out everyone, let's hypothetically pick a number, say 3. Even if you took out everyone who's been appointed 3 times by the same party, the universe of arbitrators that are left from which the institution may choose is still rather large. And they could still default to, an experienced presiding arbitrator who has 30 ongoing appointments and won't give it to any other younger women. They could default to another experienced arbitrator who for decades has been doing investor state arbitrations and not open up that field to younger entrants. And so the diversity point is important. It needs to be addressed, but addressing it by limiting the number of repeat appointments by the same party doesn't solve the problem. The diversity problem needs to be solved by consciously picking able arbitrators outside of the normal field and giving them a chance to learn and to prove themselves. Does that answer the question?
It's helpful. I guess you don't want to get closer to the numerical issue.
Well, let me get to the numerical issue then. And the answer is, it is not a numerical issue. The answer to the numerical issue is not a the answer to the numerical question is not a numerical answer. It is a fact-specific inquiry about the particular arbitrator being considered. So, for example, an arbitrator that has been appointed by Corporation X repeatedly and has always found in favor of Corporation X is a very different arbitrator than an arbitrator who has been appointed by Corporation Y and has found both for and against that corporation in different arbitrations. I think we will all agree that in the latter situation, the risk of bias or perceived bias is greatly reduced, if not completely eliminated. And so it comes down to the individual arbitrator. And by the way, on the question of Albert Jan's data on dissenting arbitrators, there was great research and scholarship in 2011, a decade ago. We don't know what the situation is today with a whole new world of arbitrators who are younger and more diverse and don't come from the old crusty world that we knew in 2011. So we don't have any current data of an authoritative, comprehensive sort that tells us whether today, as the arbitration world has evolved, repeat appointments does lead to this dissenting problem. And on the issue of dissent, I'll just add one more word. A dissenting arbitrator does no darn good for the party that's appointed him, because the dissent doesn't overturn the majority. The true test, which can't be reviewed by data, is whether repeat arbitrators in camera, in tribunal deliberations, move the needle in the outcome, not by looking at the artificial proxy of dissents. So I suggest that Albert Jan's scholarship, sterling as it is for the purposes of this discussion, is a red herring.
Finally to you, Chris.
Just a very short question. It's either for Nigel or Mahesh to respond. Tai Heng and Elaine referred to party autonomy. Now, that being the linchpin of arbitration, having an institution limit, would that not strike at the very heart of arbitration?
I think that Nigel has addressed some ground in answer to this question, and which is that I think we have seen time and again, even though it's been called a moral hazard, it's been called ill-conceived by people like Jan Paulsen, and they are arguing in favor of institutional appointments of all three arbitrators. Party-nominated arbitrators are here to stay. And the surveys year after year, more than 50 or 70% of respondents always say that that's one of the parts of arbitration that they like the most. And I suppose that's because they feel a sense of buy-in into the arbitral process. Now, when we limit the number of appointments, let's say it's 5 in 3 years, right? What that actually does is it doesn't actually affect party autonomy, it improves it. Because it actually improves the behavior of party-nominated arbitrators. And when party-nominated arbitrators, as Nigel mentioned, when you impose a limitation, then the question of bias immediately exits, because you cannot get a repeat appointment, and you know that you cannot get a repeat appointment again and again from that same party. In that sense, it promotes party autonomy. On the side of the parties, you still have the option of selecting whoever you want. On the part of the arbitrators, they don't have to be worried that there are too many appointments in X number of years. And in the example of Philip Sands, he's deriving, for example, 100% or 50% of his income from that one party that keeps nominating him 4 or 5 investor-state arbitration disputes. So in that sense, it actually promotes party autonomy and increases the legitimacy of the process. Everybody is happy. users of arbitration don't have to feel that there's a dress rehearsal with the repeat player and the same side that they're not invited to. And the arbitrator gets to eradicate this question or the possibility of unconscious bias. Let's just say the possibility of unconscious bias from his mind. So I think that's just to develop an answer that Nigel gave earlier.
Thank you.
Well, thank you, everyone. We've got a handful of questions, but we're constrained by time. In fact, one of the questions was, in fact, what Chris had mentioned, but there's a rather interesting comment, and it arises out of some of one of the topics that has come up in the discussion that's about diversity. And the comment is that while we have many diversity initiatives, it has only benefited a certain group of people. And while we've historically had male, pale, and stale arbitrators, we now have female, pale, and stale arbitrators. Interesting observation there. Of course, I think the person who put forward this question said that it wasn't her own question, but said it was from fellow practitioners. The usual, my friend is asking the question. So maybe Elaine, would you like to comment on that observation? And I don't know whether it's justified or not.
I mean, I think that there is a certain perception that there's an elite club of arbitrators, right? That the same few names get appointed, and that applies to both men and women. What I'd say to that is that just because an initiative doesn't work immediately doesn't mean that it's not worth pursuing. I'm sure everyone agrees that diversity is an important aspect of our lives, our careers, and we have to start somewhere. I'm now sort of diverging from my role as Speaker of the Opposition, just talking about things more broadly. And so, yes, in the first few years of any initiative, of course, there'll be the same few names. If you want a female arbitrator, it'll probably be someone who's already very well known, who's a little bit more senior. But with time and with more efforts by parties, by counsel, by the arbitral institutions, of course, there will be a broader range of names, and it's up to us to make it work. So let's not, get rid of the baby with the bathwater. Let's look at the positives and let's work towards that.
Thank you. So we should really give time for the initiatives to play out. Okay. On that note, the time goes back now to the judges who will share their observations on the debaters as well as deliver their verdict on the individual views. So to the judges, who's going to kick off first?
Why don't I start?
Okay, go ahead, Chris.
I actually found all four debaters very persuasive. So I'm not going to give any verdict. I'm going to leave it to the pollsters at the end of the day.
That means, Chris, you won't get a repeat appointment. Okay.
I was going to say we will.
Oh, you will. Okay. Okay, Sapna and Dana, are you going to sit on the fence or be decisive?
I'm happy to go next. I will echo congratulations to all of those who argued both in favor of the motion and against the motion. Very well done by all. And I thought that you raised some really important issues and food for thought to take away after this. So it is hard to decide. I do note that the poll result at the beginning of the event were quite extremely separated. There was a vast majority in favor of the motion to have institutions limit the number of appointments, and I am very interested to see the poll results at the end of this. But I wonder if part of that is tied to the trust and responsibility that many stakeholders in international arbitration place in hands of institutions when it comes to critical issues. And I, for one, do think that the institutions have made some really important contributions to the procedural fairness and integrity of arbitration And so in that respect, you know, I would hope that there might be a way to implement the motion informed by the views of the stakeholders that are reflected in soft law and other commentary. But I also find that there's a concern about forum shopping if the institutions are divisive and take different positions on this issue. And in that respect, you know, that would undermine to some extent the legitimacy of institutional arbitration, and that we do not want to do. So, you know, I will allow the, you know, the audience to vote. I will not decide. But should there be a movement towards institutions being asked to take the lead in this, I think it's incumbent on all of us as stakeholders in the process to support the institutions to come out in a way that supports party autonomy as well as the legitimacy of arbitration. So, and diversity, of course, which I'm a regular champion. So thank you and congratulations to all.
Paul, can I just add something to what Dana has said? I mean, interestingly, in Halliburton itself, the two of the institutions that intervene, ICC as well as SIAC-CIArb, both did submit that repeat appointments. In the case of ICC, its view was that it may more readily give rise to an appearance of bias. In the case of SIAC, it said that it may, depending on the circumstances, also give rise to such an appearance of bias. So in that sense, you know, I think the major institutions, and I'm sure with SIAC as well, are aligned.
Thank you, Chris. And Sapna, your final comments. Are you going to decide? There's a deadlock here.
Well, listen, firstly, I really enjoyed listening to all the speakers. I thought the arguments were very well made out. It is a very nuanced topic. Tai-Heng, I just couldn't get behind your very narrow framing of the word must. It reminded me of my children's favorite bedtime story when they were young, which was about two children called Charlie and Lola. And the title of the book is We Completely Must Go to London. And of course, let's be clear, Charlie and Lola were under no legal obligation to go to London. It's just because there were very compelling reasons to go there because it's a brilliant place with lots to do. So I just could not get behind that. Clearly, what the motion was really about was, you know, are there compelling reasons enough for arbitral institutions to move to impose this limit? And I was initially very persuaded by the arguments for, but I did feel that by the time you'd finished your rebuttal, you had been able to address, and once we'd got over the framing of the issue, you did manage to address really their key points such as unconscious bias, diversity, etc. And I did find myself, I found the needle swinging just a little bit to your side. So I'm not going to be as diplomatic as my fellow judges. And I hope that both the speakers and the audience will forgive me, but I'm interested to see where the audience find themselves at the end of this.
All right, the moment of truth. We've heard about cocktails, fancy restaurants, and mother-in-laws. Now we shall vote on the final two motions. First one being the one we voted on earlier, and there'll be a second one in terms of who, in your view, was the best debater. So if I could have the SIAC to flash up the poll, and could you spend the next minute voting? Okay, close the vote. And wow, a big swing. So we had a 70% odd who agreed, but well done to the opposition who were able to move the needle significantly, but still a you know, fairly sizable victory, depending on whether you're a Trump supporter, to the proposition. And and congratulations to Mahesh for presenting your arguments very well. Well, on that note, can I just thank our debaters as well as our judges for a really exciting and passionate debate on a truly thought-provoking topic, something we can take back and consider, and perhaps we'll see whether the arbitral institutions consider some of the points that were discussed today. And can I thank everyone who attended this evening, this afternoon, or this morning in your time. I hope you enjoyed this event. And we look forward to seeing you again next year. I think because it's been such a successful virtual event, I think hopefully we can do it, perhaps as a hybrid event next year where we have hopefully in person as well as we can beam it across the world. So on that note, thank you for joining us, and have a pleasant day ahead. Thank you, everyone.
Thank you.
Hi, sorry, a big thank you to our moderator, all our debaters, and our judges for the lively and interesting session. So please spare some time to complete the feedback form. The link to the feedback form will be sent to you at the end of the session. We hope to see you at our future events. Take care, everyone, and enjoy the rest of your day. Thank you.